Good morning, this is your Kelso Report for Wednesday, December 12th, and I'm your host, Clark Kelso. We begin today with a certified question from the Ninth Circuit to the California Supreme Court regarding a commercial property owner's duty to provide automatic external defibrillators to its customers. Then we turn to a loan servicing company's statutory duty to respond to consumer letters, the difference between a covenant and a condition subsequent in a property easement, an employer's obligation to accommodate an employee's disability, and finally, the consequences to a defendant of failing to follow through with a plea deal. You can imagine that the consequences are not going to be favorable. Well, let's begin with the Ninth Circuit. As healthcare technologies become easier to deploy and use, so easy that they could be used by someone without medical training, the issue is going to arise whether commercial business and other landowners have a duty to make those devices available to guests who suddenly become ill. That is the question before the Ninth Circuit in Verdugo versus Target, where the plaintiff alleges that Target breached the duty of care by not having an automatic external defibrillator available on its premises to help save a customer suffering from sudden cardiac arrest. Finding the issue unresolved under existing California precedent, and concerned that its holding conceivably affects all commercial businesses in California, a majority of the Ninth Circuit panel decided to certify the Supreme Court of California the following question, quote, "In what circumstances, if ever, does the common law duty of a commercial property owner to provide emergency first aid to invitees require the availability of an automatic external defibrillator for cases of sudden cardiac arrest?" Close quote. This is, of course, an excellent question for a torts exam, and will present, I think, the California Supreme Court with a very close question, where there are good policy arguments on both sides of the equation. Just how extensive is that duty to be prepared to come to the aid of a business customer? Next, we have a case involving consumer protection and banking law. The Federal Real Estate Settlement Procedures Act is a piece of consumer protection legislation that, among other things, provides an action for damages against mortgage loan servicers who failed to respond to certain types of inquiries from borrowers within statutory timeframes. In particular, under Section 2605E of Title 12, a borrower's written inquiry requires a response as long as it first reasonably identifies the borrower's name and account, second, states the borrower's reasons for the belief that the account is in error, and third, seeks information relating to the servicing of the loan. Well, in Medrano versus Flagstar Bank, a consumer sent letters to a loan servicer that essentially challenged the terms of the underlying loan and mortgage documents. The district court dismissed the consumer's claim on the ground that the letters did not constitute a valid, qualified written request under the federal statute. The Ninth Circuit affirmed, explaining that the statute distinguishes between letters that relate to borrowers' disputes regarding servicing, on the one hand, and those regarding the borrower's contractual relationship with the lender, on the other hand. According to the court, letters challenging only a loan's validity or its terms are not qualified written requests that give rise to a duty by the loan servicing company to respond under Section 2605E. Next, let's turn to property law and easements. Both government and private entities have now for years taken steps to preserve certain land for wildlife conservation purposes, and to restrain what otherwise would be destructive exploitation or development. The enforceability of one such attempt was before the 3rd District in Worcester versus Department of Fish and Game. Some 30 years ago, the prior owners of 4,500 acres in Calaveras County and the department had executed and recorded a conservation easement with respect to the property. The declarations in the deed required that the department post no hunting and no trespassing signs on the property, listing those requirements along with other, quote, conditions, close quote, of the agreement. The current owner filed a quiet title action seeking to establish that the property was in fact free and clear of the conservation easement because the department had failed to post the signs. The 3rd District agreed with the Superior Court that the posting requirements were technically not, quote, conditions subsequent, close quote, the non-occurrence of which would render the easement unenforceable. Instead, the court interpreted the requirements as mere covenants, the breach of which would at most entitle the property owner to some type of contract relief, such as damages. A key to the court's decision is the general rule that conditions subsequent are very strictly construed against forfeiture. The current owner was pretty clearly trying to take advantage of really a technical failure of performance to rid himself of the conservation easement, and courts should be very reluctant to grant such relief. The 3rd District's opinion is a good example of how to handle such claims. Next, employment law. An employer's obligation to accommodate health disabilities was the issue before the 1st District in Louis versus City and County of San Francisco. The plaintiff had been hired by the police department as a police officer in 1981. On December 5th, 2005, he suffered a heart attack and had 5 stents inserted. He was diagnosed with diabetes, high blood pressure, high cholesterol, and coronary artery disease. Well, following his heart attack, he took 11 months disability leave at full pay. And then, after discussions with the department, he retired from his position as a police officer after the department notified him that there were no administrative positions available that did not require him to perform strenuous physical duties regularly performed by patrol officers in the field. The officer filed suit under the Fair Employment and Housing Act. The Superior Court found in favor of the department, concluding that strenuous duties, such as making forcible arrests and chasing fleeing suspects, are in fact essential functions even of the administrative positions he sought. Although officers in those administrative positions are not frequently required to engage in such activities, the strenuous duties are still essential functions of the positions, because the department does have a legitimate need to be able to deploy officers in these positions in the event of emergencies and other mass mobilizations. The 1st District agreed and affirmed the Superior Court's judgment in favor of the department. If you're going to be a police officer, you need to be able to perform the duties no matter what your current assignment is. Finally, we turn to a criminal law case involving a plea. Now, when a defendant secures a reduced sentence as part of a plea, where the defendant agrees to cooperate in the trial of someone else, the failure to testify truthfully at that other trial is a basis for vacating the reduced sentence and imposing a longer sentence. That is the lesson from the 3rd District in People v. Peterson, where the defendant, as part of a negotiated plea agreement, pleaded guilty to second-degree murder and agreed to testify at the trial of her co-defendant. She was sentenced to 15 years to life. The defendant did testify at her co-defendant's trial, and the co-defendant was convicted. But the defendant made false statements during her testimony that created an inference she had not been an active participant in the murder. The prosecutor moved to vacate the plea, and the trial court agreed that she had made materially false statements during her testimony. So the court vacated the plea agreement, and then the defendant pleaded guilty to second-degree murder and robbery in exchange for a sentence of 17 years to life, an extra 2 years. The 3rd District affirmed, finding that the trial court's ruling was supported by substantial evidence and was not barred by judicial or collateral estoppel. The lesson here is really simple. When you agree to cooperate, you need to follow through, or your plea deal may go away. And that's it for today's Kelso Report. We'll see you tomorrow. Have a great day in the law.